Good afternoon. My name is Don Vivrette. Welcome to the webinar. As we have been doing along the way, what I'm going to do is start out first with just sort of a quick overview in terms of where we are. We are in the third week, and so as you know from the process, you've registered for one or both of the seminars. You've gotten confirmations that tell you to go get the handout. There was a bit of a delay yesterday in getting the handout, so if you looked yesterday, it wasn't there. It is there now. It was there this morning. So in case you checked it this morning, it is there at materials at It's Your Money and Estate. And I'll talk a little bit more about that in a little while. Then you cannot turn on either your microphone nor your video. Those are off for the session. Down at the bottom of your screen, and I'll show you this in a few moments, is a question and answer, Q&A. And you will ask the questions. I get them. I review them. I either respond to you or I ask the presenters where it fits, or if I know it's going to be later on, then I may wait and do that in another session. The sessions are recorded. They are there generally within a day or two of the presentations. They're in the same place as the handout material. And we thank you very much for being here. So let me touch on a couple of things. That's the website that you want to go to for the materials. When you go, you'll come into this site. If you click down in terms of It's Your Money, for instance, or Estate, if you clicked on it, it will show you week by week. Here's the handout material, as well, sorry, the presentation material, sorry, as well as any handouts or any things that normally we would have given you while you were there. And as you can see, the video for that particular week is already there when we were doing this one. These are the various charities who are participating with us. Someone had asked along the way, how can we get more information? So on that same website, there's a button called Sponsors, and you can go there and get information about them. Frequently, it will take you to the websites for the individual organizations. If you are on a PC, I'm not sure how to tell you this if you're on a tablet or an iPad or something else, but there's a slider between my picture and the text to the side of it. If you move that left or right, I decrease, which is probably the best, and it increases the size of the visual if you want to look at that. If you either click with your mouse on your screen or tap it, depending on what you have, you'll get a little box at the bottom that says Q&A. That's what you would click on to send a message to us, a question or a comment or anything else. If you were with us in the spring, we used chat. That was a different function with a different, we were in meeting where this is webinar. We're not using chat this time. You can't use it, it won't work. So Q&A is the way in which you would send us questions or information. We are in week 3, planning for incapacitation, and that's the subject for today. Next week will be living trusts. If you're with us with money, then that's the schedule for them. So the reminder each week will tell you this topic. So it lets you know as you go along. These are the physical locations we are normally in. We just wanted to say, thank you to them for when we've been able to be with them in the past. And hopefully in the spring, we'll be back to them and being able to be together in person, because it's a lot better that way than it is this way. So that's where we are. These are the charities who are participating with us. Again, shout out to Chapman University, 10 years of sponsorship. We thank them very much for participating with us along the way. And I just realized I made a mistake. So I'm going to click a couple of times here and get us to here, because today, normally when we do these in person, you would have a person from a nonprofit come in and talk to us. So in this case, Habitat for Humanity is the one we're going to look at today. So there's a video that we will watch in just a moment. There's a contact for Mary Beth. It'll be in the video also, but I just want to let you know it's here. So it will be in the handout material. It will also be in the video. So let me work on getting us the video. And so hang on with me just a moment here. And I will change this to this. Get that, share, and we will begin the video.
The goal of Habitat for Humanity is to eliminate poverty housing throughout the world. What it takes to build a house is a team. Obviously, the team that most people see is the construction team. They're out and it's very visible. But behind the scenes is an incredible force of people. Habitat volunteers are not only here on the construction site, but also in every aspect of the work that we do.
Well, in most construction projects, you hire contractors to do the building, and that's expensive. And so Habitat, to leverage the meager dollars that we have to build these homes, uses volunteers. You don't have to be a plumber to volunteer. You don't have to be a carpenter to volunteer. You just have to be somebody that wants to give some time. Today, we don't have enough people volunteering. And that's costly because the families that want to move in, they can't move in right away, and they're still having to live in the situation that they are in. So we need lots of volunteers to get this done.
With volunteerism and Habitat, it just does bring the community together, as well as it empowers each individual that they are making a difference. I appreciate being given this opportunity to do so, and hopefully planting a seed in other young people to do the same.
Each of our families is responsible for 500 hours of sweat equity. That means out on the construction site, working with the volunteers. They are helping to build the homes that they are going to be living in.
The experience of building my home was very empowering. Using the power tools, getting out of my comfort zone, just gave me a sense of confidence and accomplishment, and just kind of set the pace for what I wanted to do going forward. Seeing the community come together, seeing how many people were involved in the process, despite not knowing us, they were willing to invest into our family and help us want to do for others what was done for us.
God just directed us to volunteer here one day. And, we came here not knowing that we would own a house. We just came here because we knew that people were worse than us in our situation, and we wanted to give out to the community. It's nice to have that sense of comfort. It's part of the American dream.
I think Habitat is amazing for making this possible for us. I don't think without Habitat we would be able to afford a home. It's a great cause. We're helping not only to build our home, but we're helping to build other people's homes as well.
Oh, there's something about it. There's the good feeling that you've done some work for the day, and there's the even better feeling that you've done something for a family.
One day of you coming out and volunteering could change the life of a family forever.
Okay, Pete. Pete incidentally Pete just called me a moment ago to tell me his screen had gone dead. So there was a question of whether Pete was going to be here with us and to handle that. So I don't know if you want to talk at all about Habitat for Humanity. Otherwise, here's what I'm going to do. I disappear at this point because I keep track of what the Q&A is. So I will be invisible and occasionally speak to you guys as we go along, and you'll hear me along the way. Otherwise, it's yours, Pete.
Thank you, Don. Christina, go ahead and come online. There you are. And I'm going to introduce you in just a second. A few words about Habitat for Humanity and just the charitable part of this program. It is so nice having charities as sponsors. You don't have to listen to a commercial about opening up a bank account or a brokerage or somebody selling you annuity or something like that. And the idea that we're learning a little bit about each charitable organization is really important. Habitat for Humanity is a national organization. So if you want to benefit them in your will or in your trust, make sure that you include Habitat for Humanity Orange County chapter. That way, 100% of the monies goes to the local chapter. And as you heard, they just don't have enough volunteers. So it's a great way to give some of your time. Okay, for today's program, why don't you, Christina, go ahead and pull up the outline and get to your Ask First form. And while I just kind of give a brief review of where we've been and what we're going to be doing today. This is our third session. Last week, we had Fred Muscarella give the estate planning basics, and we learned how important title is. And that's going to come into play today as well, because depending on how your documents are titled, it gives us an idea as to what legal authority document to use with that property title. And we'll go into more of that in a little bit. The second thing is that we're going to talk about the Advanced Healthcare Directive today. And that's what motivated me to start this entire program called It's Your Estate. I was going to call it It's Your Death, but everybody dissuaded me from doing that because nobody really likes to talk about death. But in our immediate family, we didn't have any of the documents prepared, and we never discussed death or how my father wanted to die, or whether he wanted to be in the hospital or wanted to be at home. And consequently, he was on a ventilator for over 6 weeks. And then when they took him off, he died in a few days later. But for the 6 weeks that he was on a ventilator, we could never communicate with him, and just by eyesight. And so I don't want anyone else to go through what we went through. And so that's why today's topic, I think, is probably the most important estate planning document that you need and have discussed. So let's go through Christina's Ask First form, like we do all of our presenters. And I'm assuming, Christina, that your master's or other advanced degree is a Juris Doctorate.
That would be correct. Yes, I attended Western State University and graduated in 2005. And I also have an additional certification.
And what is that, and why is that important?
I'm a certified elder law attorney. And what that means is the National Elder Law Foundation has certified me to call myself a specialist in elder law. And elder law encompasses 12 different areas of law. That includes the things you would expect, such as probate and estate planning, like we're going to talk about here, but it also includes litigation. It also includes public benefits. It also includes landlord-tenant law. It includes personal injury. So basically anything that can happen to an elder, one must be proficient in to be a specialist.
Yeah, and elder law is becoming its own unique specialty in the estate planning area.
It's true. When folks come to me, they ask me, what do elder law attorneys do differently? We plan for incapacity. I tell people, I care about you during your lifetime. You know, who cares about the kids? You'll be gone. They don't agree with me on that aspect, but I tell them, you are the most important thing to me right now. I want to talk about you during your lifetime and planning in case you become ill, in case you become incapacitated.
The Elder Law Foundation, I use so frequently because I get calls from individuals who are from out of state, from out of the area, right, and they want to know what attorneys they need to go to for their parents. The National Elder Law Foundation has a wonderful referral base, and I have never been led astray. People have been very happy with those kind of referrals from the National Elder Law Foundation.
Right. I feel the same way, that I know if the person is involved in this organization, I can trust them to help my clients.
Yeah. Yeah. And how many years of practice have you been in, Christina?
Oh my goodness, it's been a whole 15 years. Sometimes it feels longer and sometimes it feels shorter. You know, I'm in that in-between stage.
Yes. You got your state bar license. We're not going to go there. You do practice law here in the state of California. You put your interest of your clients first. Talk a little bit about how you charge your customers.
Sure. Usually when it's estate planning, it's just a flat fee.
And what would that flat fee be?
Depends on what a person needs, but generally speaking, for a couple doing the will, trust, power of attorney, advanced healthcare, and funding the trust with real properties, generally speaking, that's going to be about $2,800. And then if it's just incremental things, we go price down from there.
Okay.
However, other work is at an hourly rate. I'm $4.25 per hour. I have associates who are reduced rate, and I also use a lot of paralegals to keep the rates low.
So if somebody calls you and says they need an amendment to their trust, and how do you? And then I'm assuming normally they will ask you, how much would this cost? What would be your answer to something like that?
I would meet with the client. I need to meet with you to see what you really need. And I need to look at your documents to see where are we starting from. Because sometimes we need to do a complete restatement. Sometimes it's not sufficient just to amend. We got to go back and restate most of what's in there. This happens most often when you have a trust from 20 years ago. There was stuff in there that was geared towards taxes that do not apply to us any longer, unless you have more than the estate tax exemption amount, unless you have more than $22 million. But most of my clients don't have that problem. I wish they did. I wish I did. Right?
Christina, the question you said, if it was a couple, this is how much it would cost. What if someone was single?
Yeah, generally speaking, it would be around $2,200 for a single person. Again, depending on what you need. Now, one of my specialty areas as an elder law attorney is also special needs planning. So keep in mind, if we had situations like that, it would be just a little bit more.
Yeah. And that's really important to know, because you don't want to go to someone who doesn't do this on a regular basis to get a special needs trust completed. And so you need somebody such as yourself who has some experience. And we're not going to talk about that today, but thanks for bringing that up. You're not associated with anyone who sells mutual funds, annuities, and the like. You put down false, and then you put under penalty of perjury that the above is true and correct. Is one of the things as an elder law specialist that you get people who that maybe want to qualify for government benefits and don't know how to go about doing it? Is that one of your specialty areas?
Absolutely. And unfortunately, there's not a lot of practitioners here in Orange County who do. You know, if I need to refer somebody for whatever reason, if I can't help them, I've got to look to the National Elder Law Foundation to find somebody else in the state who can. Yeah. Yes, on a regular basis, we're assisting folks with preparation and application for long-term care, Medi-Cal, and a skilled nursing facility. But the exciting thing is with the ACA, the Affordable Care Act, there's been expansions to Medicaid that now affect seniors for community-based programs. In other words, they're slowly rolling out in-home care. They're slowly rolling out assisted living programs.
Okay.
So we don't all have to go to a nursing facility, thank goodness.
Yeah. Yeah. And most attorneys, even in the estate planning area, are not aware of these kinds of new issues and what's going on. And please avoid these workshops that say, hey, we can get your parents Medicare or Medicaid qualified. Go to somebody who is an elder law specialist like Christina. You'll save money and you'll do it correctly. So you know, it's dying is just a huge business, and so you have to know who to go to get the proper advice. So today, what we're going to be talking about, the first thing we're going to be talking about is the durable power of attorney for finances. And then we'll go into the advanced healthcare directive. And then we'll go into it just briefly on conservatorships.
Wonderful.
Christina, you're in charge.
Okay, let's go.
To the next slide.
Yes. I would love to. Next. There we are. Okay, that's a little bit about me, you know, all about me now. Yes. All right, let's talk about powers of attorney for finances. There's a few different kinds, and I want to introduce you to the different types of powers of attorney that are out there. So, first, is your power of attorney durable or non-durable? Durable.
I'm sorry to Christina, and I promise I won't do this too many times, but on durable, is that a term of art?
It actually is. Durable is a legal designation. Durable means that its duration extends past the date of your incapacity. So that means that if you were incapacitated, the power of attorney that you created is still good versus a non-durable power of attorney. The non-durable power of attorney does not extend past the date of your incapacity. And people say, why would you want that? Well, let's talk about the next category, limited powers of attorney. Here's an example. Somebody might want to appoint another person to conduct business on their behalf for one specific purpose, maybe finishing up a sale of real property. But they'll put on there, but if I become incapacitated, I do not authorize the person to continue to act. So that's the one area that I can see that happening, where you have a non-durable power of attorney. Now, we explained what a limited power of attorney is. It appoints somebody to do one thing for a limited period of time. But a general power of attorney is the one we usually have. It's a broader power. It usually lists, you can pay my bills, open bank accounts, and do all sorts of things for me. And this is generally what we want, the general power of attorney. Immediate versus springing, what does that mean? Well, immediate means it's good from the day that you sign it, and you don't have to be proven incapacitated in order for it to be valid. So from the day you sign it, you have an agent, basically an employee, who can act on your behalf to question transactions with credit cards, sign your tax return, anything that you've appointed them to do. Springing power of attorney, however, is the opposite. It only becomes effective upon incapacity. And I'll say, for the most part, my clients want a springing power of attorney. They say, I am capable of managing my own affairs, and I really only want somebody else to view my financial records or contract on my behalf if I am unable to. So how does it spring into action? In the document, it'll state either certified by a doctor or 2 physicians to be incapacitated.
You know what I find, Christina, today as a fiduciary for other people, when I am trying to get the 2 letters to state that the person suffers from an incapacity, I find it very difficult to get doctors to write that letter. And I've been recommending, if you're, 75, 80 years old or older, to do an immediate one, because then that way we don't have to figure out and have you declared to lack capacity and the document is good.
I would tend to agree. And let me just share a personal aside. When my folks were about 75, that's exactly what they opted to do. They made my sister a co-trustee along with them. They made all of their powers of attorney, including their advanced health care directive, immediate. Right? They had started out with springing powers of attorney, but at one point in their life, they decided, ooh, it's time to update that. And thank goodness we did, because I agree. In an emergency, us kids could not have borne it to have to run around town and get any number of doctor's letters. And as a matter of practice, I will never put 2 doctor's letters being required. Why would you do that to your children?
Yeah. And not only that, it's a kind of to take your own parents to a doctor to have them declared suffering from an incapacity is just not a very pleasant task. And,
totally
you know,
agree.
I highly recommend the immediate over the springing, and you said it beautifully. Make sure that you have a durable power of attorney, not just a power of attorney. Let's go to the statutory, the printed, the attorney drafted. What?
Yeah, where do you get one? Well, you can go down to the Staples and get a pre-printed one. You can get them off the internet. But what I recommend folks in an emergency, if they have to get one right away, I tell them you get the statutory, durable, general power of attorney. So what is a statutory form? It's printed out in the probate code. And so banks, institutions, they all know this form and they're more willing to accept it.
Let's say somebody just doesn't want to have a living trust, Christina. They just want to have a durable power of attorney. They want an advanced healthcare directive and a will. What would you charge a single person to get those 3 documents up to speed?
A will, a power of attorney, and an advanced healthcare directive, usually around 1,600.
Okay. From my point of view, the durable power of attorney is the most powerful document, and it's probably one of the documents that's most abused. Let's go to the next slide.
All right, so powers of attorney. I want to comment on what Pete you just said. That makes people's hair curl. It makes their toes curl. It's very scary to hear that. It is a very powerful document. However, a power of attorney is not a license to steal. Misuse of a power of attorney or taking actions that are not stated within the document is financial elder abuse. So a document that does not give the person the ability to take all your money and property for themselves is not permitted. And therefore, that person has committed a crime. So I've had it where folks at different presentations have questioned me, you know, isn't that giving away the store? Absolutely not. So who is your fiduciary? And that's why I titled this presentation about planning for incapacity, the ins and outs of fiduciary relationships, is to emphasize that what a fiduciary is. They act for you in your best interest and not for their self-interest. That's what a fiduciary is and does. And that's who you're appointing in a power of attorney. So what are they called in a power of attorney? Because you know executors, you've heard of trustees. In a power of attorney, the person that you are appointing to act for your best interest on your behalf is called the agent, or alternatively, attorney in fact. The statutes use both words, and so documents often use both words, okay? So people go around town and say, I'm her power of attorney. Well, you're actually her agent or her attorney in fact. So folks ask me, who should I appoint? Well, often folks want to appoint all of their children, you know, to keep things equal. And in theory, that's a great idea. But in practice, I have found that banks and institutions don't want to deal with all 6 children all at once. And so I've even seen it to where banks have said, okay, one of you has to decline to act because we're only going to deal with one at a time. However, in cases where it is appropriate, for example, maybe there's somebody who's out of state and a parent wants the child who's here and the one who's a hedge fund manager in New York City to also be the agent, then we have to designate that the person should be able to act independently, that the agent should be able to act independently, because otherwise, again, the banks are going to require both agents to be in the same place at the same time doing the same thing, and that is usually impossible.
Do you have to live in the state of California to be an attorney in fact?
Absolutely not. There is no reason why you cannot serve out of state, and leads to another question. What if you are out of state? Do you need another power of attorney document? The answer is not necessarily, because the states have the full Faith and Credit Act. This is a contract, and other states must honor contracts from other states.
Do you recommend that people name somebody from out of state, or should they lean towards somebody in state because they're going to be dealing with banks, institutions, they want to see driver's licenses? I find it very difficult
Right.
to act if somebody's out of state.
One thing that is, I think, impossible to do out of state is open a safe deposit box. You can't do it. So while you can do banking online, so while you can make transactions online, there are physical things that very often must be done. So here's an example. You're unfortunately in need of care and in needing of placement. Your power of attorney can't do the cleaning out of your house and all of the arrangements that need to be done from out of state.
Yeah.
And those folks often look to fiduciaries to come in and step in and help as a care manager, et cetera, for those types of situations.
Yeah. Let's go to the next slide.
So you've selected your agents. Now what? What are you going to allow them to do? Okay, so I had said that something like taking all of a person's money and property for yourself might be illegal. You are only allowed to do what the document says that you are allowed to do. For the statutory power of attorney, if you've seen that, it lists different things that the agent is empowered to do, A through N, initial all of the above. However, if the powers aren't specified, the probate code actually does. I had shared that there is a statutory power of attorney form, but very often folks do have special things that are not listed under the statute that they want their agent to be able to do. One might be to create a special needs trust for a disabled loved one. Another might be personal care to place and to ensure that the person's personal and social needs are also met. Another one is planning for Medi-Cal, gifting. If it does not specify in the power of attorney document that the agent has the authority to gift on behalf of the principal, the person can't do it.
So it has to be explicitly stated in the document what the agent can do.
It does. And more, Pete, you had said that sometimes we run into challenges with our powers of attorney. More and more, banks and institutions are not accepting the language that is in the documents. And this is not across the board. This is branch by branch, institution by institution, manager on duty per day, manager on duty per day, as in it is decided by their legal departments, isn't it? That we have no contact with and no control over.
Bank of America, I'll use them as an example. They want you as a customer to use their form over their account. Should someone fight City Hall and with Bank of America and say, no, you need to use mine? Or should a customer just go ahead and use their durable power of attorney?
Unfortunately, this is the reality. There is a statute that says that a third party that refuses to accept your power of attorney can be held liable. But as you said, Pete, are you really going to fight City Hall? Are you really going to sue Bank of America for not accepting a form? In fact, I have been told by employees at Bank of America, yeah, you go right ahead. Come get us. Yeah. So the answer is you have entered into a contract with those institutions. You have accepted their policies, and therefore, since they have your money, we've got to go along with their rules.
Yeah. So if you have a durable power of attorney today, take it to your institution to see whether or not it's going to be accepted. And if not, if they don't accept it, then go ahead and complete theirs. Public employment retirement system is the same thing. They want you to use their form. One of the reasons I believe is that if the durable power of attorney form is a fraudulent form, are the institutions held liable if they give away money under that form and it turns out to be fraudulent?
That is exactly what's going on. Let's just call it CYA, that banks and institutions have been held responsible and, aiding and abetting of financial elder abuse. They're
And-
mandated reporters of elder abuse. And so that is why they are so darn tough about what documents they'll accept.
And sometimes, people believe that financial abuse occurs by either the caregivers or some people outside of the family. And statistics show that family members are the ones that commit the financial abuse. And sometimes there's competing durable powers of attorney forms that a bank or an institution has to try to figure out which one is valid and which is the latest. And so from my point of view is they need to go to somebody like you to get their durable power of attorney form and avoid the statutory one altogether, because it's such a powerful document.
Pete, let me ask you a question. If I have a power of attorney, does it end when I die?
Good question.
Wonderful. Yes.
So
That's the answer.
whether it's durable, springing, or anybody else, it ceases to exist when you die, because then your trustee or your executor is taking over at that point.
Yes. Now, I've heard other families from other states have had different experiences with their state powers of attorney. And this will be different for the Advanced Healthcare Directive. There is one power that extends past death, but the power of attorney is defunct upon death.
Yeah. Let's go to the next slide.
So we had said most folks believe that they are the power of attorney. No, that's the document. You are an attorney in fact. And this, Jane Doe by John Doe, her attorney in fact, that's actually the legal way that we actually sign. Though try to fit that on a checkbook, right?
Yeah,
So-
and it's for practicality purposes, people sometimes wonder, where do you use this document? Well, sometimes you need to sign a tax return for another person. Sometimes you need to get into an IRA account. Sometimes you need to deal with insurance for the other individual. These are all documents that you can't use your trust to do. You have
Very
to
good.
you have to use the durable power of attorney.
Yeah, let's introduce that issue right now. Some folks have asked me, what's the difference between my trust and my power of attorney? Your power of attorney is your agent as your employee to do business on your behalf. And that might be banking, that might be real estate transactions, but it is also liabilities. It's bills, it's paying for things, it's entering into contracts, and none of that stuff is necessarily for the trustee to do. What does the trustee do? They manage the property in trust. Bills are not assets in trust.
And so it becomes very important. I just went to US Bank this morning, and it turns out that the person I had brought the durable power of attorney form, but her bank account was in the name of her trust.
Mm-hmm.
The durable power of attorney had no impact on that whatsoever. Nope. So here again, you have to understand how the accounts are titled so that you can have the proper form to take to the institution. Let's go to the next slide. There you go.
All right. So folks ask me, is this revocable? What if my arrangement doesn't work out? Yeah, absolutely. Powers of attorney are subject to revocation of the principal. I tell folks, when you create a power of attorney, it doesn't stop you from doing anything. You've just hired somebody as your agent to act upon your instructions, but you may revoke your power of attorney at any time. Now, sometimes powers of attorney expire per terms of the instrument. We said like limited powers of attorney to do one thing. Once you've done that one thing, the document expires. Now, this is interesting. If all the powers of attorney, or pardon me, I did it again. If all of the agents pass away before the principal, that power of attorney is defunct. You got to have agents in order to have a valid power of attorney. We'll talk later what happens when your power of attorney fails.
Okay, let's go to the next slide.
All right. We had talked about this before. You can't fight City Hall, so just use their darn forms.
Yeah, one more comment on this is that many banks and financial institutions put an internal time limit on the document. So if they see a document that was drafted 5 years ago, they may not accept it. It's not. What is the law on that, and what is the practicality on this?
Yeah, so here's the law that you must accept a properly executed power of attorney.
So no matter how old.
Exactly. There is no statutory expiration date on a power of attorney. But once again, they've got your money. They've got the power.
Yeah. So if they see their document for the very first time and they believe that they use the word stale, they may not accept it.
I've certainly heard that before. But
yeah.
As you said, Pete, there is no statutory staleness under the law.
Let's go to the next slide.
All right, I want to take a minute here and talk about who can enter into these documents. This is real important. Who has capacity to sign a power of attorney? So if somebody tells me my mom has dementia, can she do a power of attorney? And I said, well, I'll meet her and I'll talk to her, because a diagnosis of dementia is not an exemption from having capacity. And I've noticed for some folks, I've had the experience of maybe I'll go and meet them and they're just not having a good day. And then the next time I see them, they're a totally different person, able to answer questions, able to ask intelligent questions and appropriate for the circumstances. So, there's a lot of faux dementias out there, dehydration, UTIs, different situations that may cause dementia like experiences for people. However, I tend to give folks an opportunity if it seems like maybe another time would be good for them.
And if they lack capacity to do it, what happens?
Conservatorship. And we'll talk about that at the end. Okay. But for this particular decision, for making a power of attorney to appoint somebody else, this is the highest level of capacity. One must not only know what day it is and who the president is, but they must be able to understand the benefits, the risks, the alternatives, and the results of what they are doing. To enter into a power of attorney, you're entering into a contract and you must have the highest level of capacity. Next down is medical decision making. So you must understand, maybe not in medical terms, but you must understand what it is what decision it is you are making, the alternatives, the outcomes, etc. Now, for testamentary capacity, this is just to sign a will. It's very low. Do you know what you own? Do you know who your kids are? And do you know you're signing a will at the time that you're doing it? Different than what we just talked about to enter into this power of attorney. Now, the lowest level of capacity, you need to breathe and say yes or no in order to get married or divorced.
Really?
That is true. All right.
right. So we've kind of done the durable power of attorney for finances. And so if anybody has any questions on that, but that's just a absolutely important document to have. And again, recommend highly you do the immediate, make sure that it's durable, and please see an attorney. Do not get a store-bought form or do it yourself. It's just too powerful of a document. The Advanced Healthcare Directive, what is it?
All right. So this is the power of attorney for healthcare, but it is so much more. This is the document that states who's going to make your medical decisions if you cannot. What instructions are you giving for your end of life care? What other personal instructions are you giving, including donation and other things?
So you're giving somebody legal authority to make the medical decisions for you.
That's right. So let's be clear about this. Nobody has authority to make medical decisions for you without this document. Now, generally speaking, I think families have told me that the doctors and hospitals are open with them and want to communicate with them, but they have no actual authority to be making medical decisions absent this document, this Advanced Healthcare Directive. And it is absolutely necessary in cases where maybe not all the family members are in agreement.
Yeah, and that's what happened in our family. That I have three sisters, and all four of us saw things through our own rose-colored glasses, and therefore the doctors didn't know who to listen to. And we didn't have the Advanced Healthcare Directive. So that meant he stayed on the ventilator. And so stuff is really, really important.
Right. So this can be the tiebreaker between the children, is your own words saying, here's what's going to happen to me. This is what you will do because I am appointing you as my agent. All right, so this is the most important thing, that you are, in fact, among many other things, giving instructions to the agent on when to withhold or provide life-sustaining treatment. And so, as you say, that's absolutely critical to avoid discord. It's absolutely critical to avoid treatment that the principal did not want. So, what other types of things can we include in our powers of attorney? End of life wishes. Some folks add very extensive addendums, sometimes pages, and you are free to add whatever you want. There's specialized language for religious observation. And one thing that you and I had been talking about, Pete, was that the Hemlock Society, I see, is one of our charitable sponsors, and they put out this great addendum for powers of attorney for COVID.
Yeah, it's on the materials website. That's where we put it. So anybody who wants to take a look at that and put in some special instructions for COVID. It's just been misery for families having people in the hospital or in assisted care facilities. It's probably one of the reasons too that with the restrictions on travel, it's a good idea to have this conversation when you're healthy and you have all your senses about you. And I find that most attorneys don't spend a lot of time on this form. And you mentioned that, do you use your own form on this, or do you use the California Medical Association one? Which one do you?
I do the CMA. And I'll tell you why I use this, is because doctors and hospitals have often said, in an emergency, I do not have time to read your 10-page addendum. I don't have time to look at the circles that the things that you circled on the pages with the pictures. I don't have time for that. I need to know where where to get my answers, who can do what, and what am I going to do? And so
Yeah.
that's why I use the
Yeah.
CMA form.
Yeah, and it's you can go online and get that form. I think it runs you $10 for 2 forms, and I highly recommended it as well because again, nurses and doctors are familiar with it and they understand it. But these are the legal forms, and to give another person the authority to act on your behalf only if you can't communicate yourself. So even if you've given that authority to another individual and you're able to speak to your doctors, and this form has no power whatsoever.
That's right, unless you've made it an immediate document. And some folks have, for example, for their spouse, that they always want to ensure that their spouse is kept up to date.
Yeah. 5 wishes, it contains both questions and the statutory form. Is it also good for California?
Absolutely it is. Yes, that's right. What did we say? That you don't have to have a California specific. You should, but California is empowered. California institutions are empowered to accept documents from other states.
Let's go to the next slide.
Okay, so what makes a power of attorney for healthcare or an advanced healthcare directive valid? One is it has to be dated. That's a requirement. And it has to be signed by the person creating it or signed at their instruction. And it must be either notarized or witnessed. And I've definitely seen it where somebody had the statutory form, but they didn't do that last step. They didn't have witnesses or they didn't have it notarized, and therefore it was invalid.
Yeah. Right now, to enter into the hospital, almost when you're at the admission desk, they'll ask you to complete that form right there and then as to who is going to be your agent for your health care. Probably not a great idea to deal with that issue at that particular point in time. So, the durable power of attorney for finances is talking about money. And I see most attorneys recommend that you keep that document kind of close to your vest, especially if it's an immediate one. On the advanced healthcare directive, is that a document that you ought to keep close to your vest as well?
Definitely not. I think that you should instruct your children to have a copy in the glove compartment. The good thing about these documents is that hospitals often want to see them in digital format anyway. They're not going to take your original, they're going to scan it and give it back. So what I've often recommended is, hey, scan this and email this to your kids so that they're going to have it on their phone along with your post in case of emergency.
Okay, let's go through the list of a witness.
Yeah, exactly. So I'm still talking about what makes your power of attorney valid, because why go through all of this only to find out that your agent can't act on your behalf or follow any of your wishes? So the witnesses can't be the doctor. It can't be any of the caregivers in a facility. And it cannot be the administrator at the assisted living. So you got to find independent folks. And even though the law doesn't specify that it can't be a family member, it should not be. And let me share with you how these institutions are acting over and above the law. My dad had a power of attorney and we needed to take him to the VA hospital. The VA hospital did not like something about the notarization. And let me assure you, I reviewed it, it was valid, but they didn't like the notarization, and so they would not accept it. Now, fortunately, my dad thought ahead and he had their darn VA power of attorney advanced healthcare form already on file. So we were able to make decisions on behalf of dad, thankfully, gratefully, and no thanks to the VA.
Let's go to the next slide.
All right. What about folks who are in a facility? You got to call the ombudsman. Folks who are in a skilled nursing facility, this is not an assisted living, this is not a residential care facility, but a skilled, not even the hospital, but a skilled nursing facility, you got to call the county ombudsman who's assigned for that facility. So apparently there was a lot of fraud going on in the past where folks in skilled nursing facilities were making healthcare decisions, maybe end of life decisions that were influenced by facilities, I guess. And therefore a whole volunteer agency sprung up, the ombudsman, to ensure that folks who are entering into advanced healthcare directives in a facility are doing so willingly.
And the ombudsmen are wonderful folks. They, I don't even think I think most of them are volunteers.
They are.
Yeah, and I find them to be very informative and do not hesitate to call. Please understand also the economics of the situation. When you are in a hospital, you do not have normally your primary care physician be your doctor. You have what's called a hospitalist. And when you go to a skilled nursing facility, your primary care physician and a hospitalist from the hospital is no longer in charge. It's the medical care director for that facility that makes the decisions. So your agent for your healthcare is almost your advocate, and they need to be local. They need to know what's going on because you want the best care possible that you can have. And when you go to a skilled nursing facility, you have 20 days after you've been in the hospital, at least for 4 days, that Medicare pays for totally 100%. But you certainly want to make sure that you're not dismissed from the skilled nursing facility too soon. So you need an advocate.
Absolutely. And that is why this document is so critical. But a little while ago, Pete, you said, does the power of attorney ever expire? And I said, no, under the statute, it absolutely does not. However, the Advanced Healthcare Directive does. The law says that advanced healthcare directives that were executed prior to 1992 are invalid, that they are expired. Now, the interesting thing is I've never seen a hospital deny an expired power of attorney. However, that's what the law says. So that leads us to another question. Folks often ask me, how often do I need to redo these documents? Well, in general, I'm going to say, if you're over age 65, probably every 5 years.
Yeah.
Take a look at it every 5 years. Have there been many changes in the law since then? Only a couple. One is that you want to make sure there's a HIPAA waiver on your power of attorney.
And what does that mean?
The Healthcare Privacy Act. In order for your agent to be making medical decisions, they're going to have to have access to your private records. And if you don't have a specific HIPAA waiver allowing your agent to see your medical records, and they don't have authorization to see them.
Yeah, and they won't. Medical records will not allow you to see the patient's records without that HIPAA release.
Right. So the only other change that has been made to powers of attorney for healthcare or advanced healthcare directives was some minor language about physician appointment.
The other thing too is what I find is the medical doctor who's the hospitalist or the medical care director at the skilled nursing facility, when they listen to the agent, they want to make sure that the agent has spoken to the principal. And how long ago have they spoken about their medical care? Because people change their minds on many occasions as they get older and may not communicate that to the agent. So it's that whole theory again of the document may be stale. So as you get older and, you know, you have a difference of opinion, or I would even recommend for those who are 85 and older to make sure that that advanced healthcare directive is less than 3 years old.
Very good. And let's just add one more layer onto that. I had said, make sure that your agent has a copy of your document along with the post. And many people have had this experience, right? Who've gone into the hospital with a loved one and they've been chased down the hall with this pink form that they want you to fill out.
What is a post?
Physician order for life-sustaining treatment. And this is not a legal form that you would do with your estate planner. This is a medical form that you would do with your healthcare provider. And it allows you to make the decision. If you are in cardiac arrest, are you going to have CPR or are you not going to have a CPR?
Yeah.
And then if you do, then what are you going to do afterwards? And are there limitations on hydration and nutrition and other treatments?
Yeah, I'd recommend a post for individuals that are believed that they're maybe are within death or dying within the year. But I don't recommend a post just to do a post for younger individuals, or if there's no serious illness involved.
Right. But the point is that the hospitals will chase you out to the parking lot with the pink form that has already been filled out to do DNR for your loved one. So don't be afraid to say no.
No.
So
Yes.
Pete, let me interject something. Two things. One, there's a question if I'm supposed to have my advanced healthcare directive reviewed every 5 years, for instance, how much does it cost to have it reviewed?
It's not if the form is from the California Medical Association, unless you had it completed by an attorney. It's mostly about what kind of treatment do you want?
No, not the post. My advanced healthcare directive. So
yeah.
Am I supposed to have that reviewed from 1992 to now is a bit longer than 5 years, but am I supposed to have that reviewed every few years?
Right. What Pete was just saying is if you have a statutory advanced healthcare directive or a CMA form, just look it up to see what does the form say now, but also take a look at it yourself. Who are my agents? Are they still the appropriate persons? What did I select? Did I say put me on life support and then keep me on life support forever? Is that what I said 10 years ago? Look at those things to see, does your document suit you presently? As far as the changes in the law, just go to the statutory form.
Yeah.
To
And
see.
there's not that many changes. So it's mainly about how do you feel about who you've chosen? Can you, and you're older and you may change your mind. And so, but this is the document is the legal authority. It doesn't tell you much about, it has a check-a-box, and the check-a-box is that, do you want me to use all medical options available to me to keep you alive? Or, do you want to have that limited? And it's very vague and it's open to a lot of interpretation.
Okay, let me stop you at that point. So the post, it's POLST?
Correct, and it's a pink form, and it's usually hospitals and medical doctors give you that form.
And just as a note, Pete and I disagree on this one because, for instance, in my sister's case, she's in Santa Barbara. I'm her primary person to take care of healthcare, but I'm in Laguna Beach. So she has a post on her refrigerator because that's where the paramedics will look and they will react to that medical order by the physician. And that's in place because I'm not going to be there in 20 minutes. And therefore, that is what she has in place. She's not anticipating death, but that's what she has in her place because there's nobody else immediately to respond.
Yeah, there's
I
also
disagree on that one.
Yeah, there's also another form called a do not resuscitate form, a DNR. And, it's, and again, that's not a legal form either. but I wouldn't complete a DNR form unless, you know, I was on my second bout of cancer, or if I was so frail that if somebody did CPR on me, my rib cage would collapse, or, you know, DNRs is a very serious matter. And so you have the Advanced Healthcare Directive, you have a POLST, you have DNR, and then you have even, you have to understand what's the difference between hospice and palliative care. Christina, have you had that question posed to you?
No, I have not. No, I don't know that that's actually a legal designation. I don't know that palliative versus hospice
Yeah.
is a legal designation.
Well, you know, hospice is where it's totally comfort care. Palliative is where you can do comfort and a procedure to cure you. You can, it's a combination. And so, but hospice care is mainly for individuals who have a 50% chance of dying within the next 6 months. And so again, you know, you need to talk about these things with your agent. And where do you get this information? On the website, on the material side, I put in a material on what we call the Your Way booklet. And the Your Way booklet is available to every person for free. And it's done, the organization is called HELP, and they got a special grant through the Amundsen Foundation, and they put this booklet together just to get you some talking points. It's not a test, but it's certainly, it's a little bit more in depth than checking a box. And it allows you to go into areas where, do you want a stomach plug? You know, some people need a stomach plug to get through a small stage after an operation to get their internal organs to go to work. But if you're in the dying process, having a stomach plug put in for food is just contrary to nature. And so your agent, again, needs to be aware of your feelings. What do you want? And when do you want this? I had an individual.
Pete, let me
Yes.
interrupt you for a minute because I don't want to go too far into this. Christina, I have a question for you. We have 20 minutes left. There are a series of questions in terms of what about? Do you anticipate having time at the end, or do you want me to ask them now?
Are they regarding this particular subject or general
So I have
questions?
3 children, and my power of attorney says, and healthcare says, majority rules. Do all 3 kids have to be there?
Oh, okay. All right. I'm going to hold off until the end. We have
None of my
approximately.
agents are in the area. They're all out of state. How do
Okay.
I handle this? Could they
Don,
do things? Yes.
Don, can you hear me? I want to hold off until the end of our presentation, if we may, because we've only got about 6 more slides that we really need to hit
Thank you.
before we can get into those questions.
Let's go
Is
on.
that all right?
Yeah, let's go on, and should be done in about 10 minutes.
Wonderful. Yeah, I'm really excited about hearing those questions. All right. So, Pete, I want to share with you, I use the Your Way because the statutory form doesn't ask the questions about whether you want palliative care or hospice care, whether you would go for a G-tube. It doesn't get into the nitty-gritty. It doesn't say what are your values at end of life. And I think that's the most valuable tool for your agents.
Keep it open. You know, you don't know what's going to be the state of an emergency at the time when you're in the hospital, just so that the agent knows what you want and then can make a decision based on the circumstances at that time.
Yes, exactly. That particular publication list. What are your values? Is it being able to communicate with others? Is it being able to get in and out of bed by yourself? What is quality of life? And what is the point at which you will terminate ongoing treatments?
Atomical gifts.
You have the ability to put that in your advanced healthcare directive.
Let's
And
go
I
to
don't
the
know
next.
about you, Pete, but most folks tell me there's nothing anybody's going to want. So say no.
Yeah, I worked with the Red Cross, and they basically said that anybody over the age of 50, more than likely, they're not going to need any of your parts. But
Good
let's go
to
to the
know.
next slide.
Right. All right. So what we were talking about was we were talking about the pulse. What else is there? So I had kind of said have a little arsenal for your agent. If you have a pulse, make sure that they have it. And we didn't discuss this, that the pulse can be renewed, right? Every time you go into the hospital, they'll chase you around with a new pink form. So to be clear, the pulse supersedes your advanced healthcare directive. All right.
Okay, let's, we're
Can
not
I
going to
say-
get into the trustees.
All I want to say is what we talked about before is the difference between the power of attorney and the trust.
Okay.
So the trust covers assets that are titled into the trust. And what is titled in your trust is maybe it's your bank account that you've listed. Maybe it's or gone down to the bank with your trust and said, put this in my trust. It might be your home and other real properties that you've transferred, but it is not your IRA. It is not your 401k. It is not your retirement account, because those can only be owned by individuals. And so that is one of the reasons why the power of attorney is so critical.
Yeah.
Trustee
And
can't
we're going to spend
trust.
an hour and a half on being a trustee and also about living trust. So I think
So we're going to skip that.
We're going to skip that. We're going to skip that. Spend 5 minutes on conservatorships.
So we had said, what if you don't do it? What if you're unable to do it at a certain point because of capacity, like we were discussing? You're unable to articulate the pros and the cons and the alternatives of entering into this particular contract. The answer is conservatorship. Conservatorship is not desirable because it is very public and time consuming and expensive.
Very expensive.
So the types of conservatorships that are available are the probate conservatorships. This is for somebody who became incapacitated. Generally, this is for somebody who is elderly or has had a traumatic brain injury. Limited conservatorships are for younger folks, generally folks who were diagnosed with developmental disabilities such as autism before the age of 18. LPS conservatorships are handled in the mental health department of the probate department of our court systems, and that's for involuntary psychiatric treatment and placement. But amongst all those different types of conservatorships, there's conservatorship of the person, which I say is a legal substitute for a advanced healthcare directive. This is what you get if you have not done that planning.
Yeah. Can you name, in the event that you do need a conservatorship, can you name individuals that you want appointed in any of your documents?
Absolutely. I think it's critical that you do so. In your documents, you will name, and if I need somebody who is my conservator of my person or of my estate, here's who I wish to have, and here are their successors.
Okay.
That's a great point. Now, let me distinguish conservatorship of the estate. I say that that is a court-ordered substitute for a power of attorney.
Yeah. Yeah. And as you said, it's very expensive.
Darn it, it is expensive. Just to file anything in Orange County is $495. The assessment is about $600. And then there's a bond, and we're not even talking about legal fees. Yeah, it could be several thousands of dollars. And it doesn't end there because you have to annually or biannually report. So it's about $5,000 every 5 years.
And then
Just do
there's
your
maybe,
estate plan.
yeah. And then a lot of times family members compete as to who is going to be the conservatorship. And so it can easily escalate anywhere between $10,000 and $25,000 quickly.
Or beyond. I've certainly
Yeah.
experienced that. So, conservatorship of the person is for somebody who cannot provide for their own food, clothing, shelter, or medical care. And this person is empowered to make decisions about placement. They have the responsibility to provide for basic needs, and they make medical decision-making choices. But the interesting thing is the one on the bottom is the agent under the Advanced Healthcare Directive has priority over the decision making of the conservator. So these two things can still exist at the same time. In order to place anybody in a facility, powers of attorney generally don't say, and if I need to go into a secure memory care facility, you have the power to do that. Well, interestingly enough, nobody actually has the power to place you in a secure perimeter under a power of attorney, unless, of course, you've stated that they do. So very often, in order to place somebody who maybe wanders or engages in dangerous behaviors due to dementia, very often a conservatorship is necessary for that purpose.
Yeah, and today the courts are just jam-packed. So it's that's why you want these documents, so you can avoid the conservatorship.
Right. Let me talk for a moment about conservatorship of the estate. Again, I had said that a conservatorship of the estate does not prevent, or pardon me, that a power of attorney for assets does not prevent a person from doing whatever they want. So there have been times where a person with dementia, might be functioning in many areas of their life, but has been unable to resist fraud and undue influence. They've been scammed over the internet or what have you. And so sometimes, even when there is a power of attorney in place, a conservatorship of the estate could become necessary.
Yep. All right.
All right. I think that's it for me.
Yeah, no, there's the Your Way booklet and the Pulse. Learn about it. Stay in control of your money and your life by choosing the appropriate fiduciaries, whether it be family members or a professional. They need to do what you want them to do, not what they want, okay? You're in charge. The longer you stay in charge, the happier you're going to be, the longer you're going to live. Dawn, what are some of those questions?
All right.
No, first I want Christina to go one more slide.
One more slide.
Okay, another one. There, no. Yes, there. Thank you. Just to make sure people can get a hold of her. Okay, now I'll tell you the questions, and we'll leave that up for a minute, and then we can get rid of it. Okay, so I have 3 children, and my rules say majority rules. Do all 3 of them have to be present? What if one's missing? What do we do then?
Okay, so I think I understand. The power of attorney says that the majority rules. And what is the decision that is proposed? Does it sound like it's for an advanced healthcare or a power of attorney?
I will read you the question. My power of attorney is my 3 children under majority rule. Do they all have to be present at the same time when I become incapacitated to talk to my doctor?
Wow. I would say the doctor would want to have all 3.
Pete, why don't we let Christina answer?
Okay.
No, I think that's why I was a little bit confused. So it sounds like we're talking about medical decision making. Is that what you believe that question says, Dawn?
Become incapacitated to talk to my doctor would tell me it's healthcare.
Thank you. All right. Now that I think I understand the question, yeah, If it says that they all have to be there, then that means all three of them have to have input. Now, does it mean that they have to physically be there? No, because one can FaceTime. Doctors and hospitals are in fact willing to, make contact electronically. And that's just the reality of the modern world. But
So-
yeah, what
so
happens if they don't agree? It goes before the hospital's ethics board. They try to help mediate a decision, and otherwise they'll do nothing except do life-sustaining treatment.
Okay.
Unless somebody goes and gets a conservatorship. This is one of those events where a power of attorney could fail and necessitate a conservatorship.
Yeah,
Okay.
I would recommend highly that you do it in succession.
What does that mean?
It means that you name one of your child first, then you name the second child second, and then you name the third child third in any order.
But then I have to pick favorites.
Yep.
Okay. So the next question is, and I'm going to read it to you. If health card agent lives out of state, can any actions be instructed by phone, or how does it work? I'm not
Yes.
near any of my agents.
Yes, they will talk to your agents by phone or by video conference. However, the agent does things for you that isn't necessarily just talking to doctors. I mean, they might need to interview caregivers, things like that, to actively participate in your care. So, like Pete had always said, even though the world is digital, it really is a good idea to have boots on the ground.
Yeah, there's many a time when I have called in and said everything was hunky dory, and then when I go in, it's not. The person hadn't been shaved in 4 days. They were
Okay.
reluctant
Pete,
to take a
Pete,
shower.
Pete, okay. So the next question is, please explain POLST form again.
Physician order for life-sustaining treatment. And what this is a form that overrides whatever you stated in your advanced healthcare directive about end-of-life choices in case of an emergency. So the first question that exists on it is, if you are having cardiac arrest, do you want CPR?
Okay, and the important part about the POLST in my mind is it is physician ordered. It is signed by the doctor. So it is a doctor's order that a medical facility is looking at.
That's
And
right.
that-
It's not a legal form at all.
No,
So
but it's a doctor's order.
under the resources, I've placed where you can get a copy of this POLST. And this is something that you can discuss with your doctor as to whether it's appropriate for you given your circumstances.
Yeah, and please understand it, and it works well in some circumstances, but most medical primary care physicians have between 1,500 to 5,000 patients. So, when you go into the hospital, you've got a hospital list. So I would rather depend on my healthcare agent versus a doctor's physician's order. But that's personal.
Yes, it is. Okay, there were a lot of questions in terms of the Your Way booklet. You've covered that with the name, although apparently someone went out and tried to get one, and it will not allow them to proceed past click to add to cart button. I honestly can't answer that question. So that's their site, not ours. Call them.
Yeah, call them. They have a telephone number right on the booklet.
If I want to name a conservator in case, if you want to name a conservator in case you need one, which document does that go into?
I place them in the power of attorney for finances. That's where I nominate. It's called a nomination of conservator. So it can be a standalone document, in fact.
But yeah, and then for the healthcare, you could name for the person, you can name the person there as well.
Okay.
That's right. So either within these power of attorney or advanced healthcare documents, or in a separate document unto itself.
Okay. The last question that I have is the POLST valid in all states, or is that a California document? And really, it's a doctor's order. It's not even a legal form.
Exactly right. You answered the question, Don. This is an order from your doctor. And what's more is it is also a contract, and contracts are enforceable across state lines. So if you've said, yeah, give me CPR, then you can expect a doctor or a hospital to recognize that out of state.
Very good. So Christina, if you want to stop sharing your the red button. There you go.
Hey,
I'll come back. Okay, we've covered a lot of subjects. I answered a lot of questions along the way. We have a record of all the questions that were asked. We'll review them and make sure everybody gets answered. Some of them I deferred off to next week because it didn't fit into these subjects. So Christine, I thank you very much. Pete, I thank you very much.
We've got I think about 5 minutes left, or am I reading it wrong?
You're good. You go ahead.
Choosing your agents, either for your advanced healthcare directive or for your power of attorney, is a really important decision. And don't just name the eldest. Don't just name, hey, because they're a male. I really discourage people from naming somebody from out of state, because I think digitally, you just don't see the person and you can't look them in the eye and find out actually what is going on. Care facilities have to be visited. You can't just pick one out on the internet and expect it to be okay. You need to meet with the staff. How long has the staff been there? If you need home care, it's just, what caregiver are you going to bring in? Caregiving services, it is super expensive today, anywhere from $10,000 to $25,000 a year just for 24/7 caregiving. And so, and have these things done while you are in a good state of mind, when you're healthy, when you could sit down and talk to someone. Don't make these okay, now we have an emergency. Now I've got to decide as to who to pick, and make sure that they can fulfill your wishes. Religion becomes a very important thing. We had two Catholic sisters, not sisters in sisterhood, but actual family sisters. And one felt that she was committing a mortal sin if she decided to withhold CPR. And the poor,
Pete,
yes.
I'm going to stop you because we have more questions.
Sure.
So let me stick with this one. I understand your religious beliefs. I don't have children, and niece and nephew are out of state. Who should I choose, and can I hire someone? The question did come up before in terms of, can I hire a trust company or a private company corporation to handle this? I'd responded that a lot of times they don't want to deal with health. They'll deal with the other side of it. You could probably recommend someone who would be able to help out with that if need. Yes?
Well, my recommendation would be talk to somebody like Christina, who works with professional fiduciaries in the community, and she will line up what she thinks is personality and competence wise somebody appropriate for you. There's about 60 licensed professional fiduciaries in Orange County, and there's an association for the professional fiduciaries, and there's a licensing bureau for professional fiduciaries. And you should
does an agent get paid? Clearly a fiduciary would, but what if it was a family member?
That's totally up to you as the employer, whether or not you want them to be paid. Christina, do you have a comment on that?
The law says that if the document doesn't otherwise provide, that they are entitled to reasonable compensation. Okay. And what's reasonable is whatever is customary in our county.
And here's the real challenge. I think this is a really wonderful question to end on, because this is a toughie. How do I know if these people are honest and looking after my best interest? And that's a doggone good question.
That's a doggone good question. So here's what I say to folks. If you don't think that you can trust them, do not appoint them as your agents. So the question prior will tie back into this. Let me share with you that I have many clients for whatever reason cannot appoint their children. Either they're not good with money, they might have some issues along those lines, past experiences with those children, or they don't have any, or anybody close who would be appropriate. I'd say maybe every other family is saying, so if this person can't serve as my agent, can you recommend who can? And I do tell them how to seek out a professional. I mean, this is a big job for somebody. It's not necessarily a job that anybody really wants in some cases.
And I'm going to ask you the question that Pete did not ask you when you were going over your ask first form. So if someone sends you an email and says, I attended your class, will you give them free advice?
No, indeed. My advice is valuable. I'm giving you something of value. And so I will set an appointment. Excellent question.
Okay. Thank you. Okay, we're 3 o'clock. I thank you very much again, Pete, Christina. I appreciate it.
Christina.
Thank you. It's been fun.
For being with us on the line, and we will see you again either next week, Tuesday or Wednesday. So take care. Stay safe.
Have a great day.